Good afternoon, everybody. My name is Harvey Ryder, and I'm one of the coordinators of the Brown Bag Lunch Series. I want to thank all of you for attending today. Our co-sponsors are the Jewish Community Relations Council of Greater Washington, the Jewish Federation of Greater Washington, Tzedek DC, and the American Association of Jewish Lawyers and Jurists. So a number of you have been here before. We haven't been in person for a while. I'm hoping we'll be able to do an in-person event sometime in the coming months. But we've asked you all to stay on mute. And so I'd like you to do that. If we have a chance, depending on how many people are online, we may just open the lines. If not, what I would suggest is that you put questions you have in the chat box. I'm not going to do a long introduction. Some of you who've been to our prior Brown Bags have probably heard Art speak. He has been our most frequent speaker over the years, and he's going to talk about the past Supreme Court term and some of the cases that may be coming up this term. Art is the senior counsel at the American Civil Liberties Union of the District of Columbia. And I hope you've read his resume. I'm not going to take up the time today to talk about all of the tremendous work he's done in the civil rights and civil liberties areas over the years. But I want to welcome Art, and then we'll have plenty of opportunity at the end of his presentation for you to ask your questions. So Art, thanks for coming, and good to see you again.
Thank you, Harvey. And I miss my bacon cheeseburger for lunch, but we'll have to postpone that till next year. And it's nice to see some familiar faces and some familiar names. Thank you all for coming. I'm probably going to talk too fast because I've got many things to try to cover. And as usual, because I'm speaking to a Jewish oriented group, let me start with cases that have a religious angle. And I'm going to talk first about stuff that happened last term, and then try to save enough time to talk about the coming term, which starts on the first Monday of October. So the first case was a fairly simple one and not particularly a religious one, secondarily a religious one. It was called Shurtleff against City of Boston. It had to do with a Christian flag. In front of Boston City Hall, there's a plaza with 3 flagpoles. They usually fly the United States flag, the Massachusetts flag, and the Boston flag. But the plaza is a public forum where various groups assemble and hold programs. And the city has had a practice of allowing those groups to fly their own flag during their programs. Often these are national days. The people of Ukraine have their national day and fly the Ukrainian flag, et cetera, et cetera. There have been interest groups that have done the same thing. For example, a pride flag. But a Christian group got a permit to hold an event and wanted to fly their Christian flag, and the City Fathers of Boston decided that was a violation of the Establishment Clause, and the lower federal courts agreed with them, and the case went to the Supreme Court really as a First Amendment case and not as an Establishment Clause case. The question was whether these flagpoles were public fora by the practice of Boston allowing anyone to use them, and the court 9-0. An opinion by Justice Breyer, who of course comes from Boston, that indeed the flagpole had been treated as a public forum, and there was no problem with this Christian flag flying, and indeed Boston was required to allow it to fly so as not to discriminate based on the message, the viewpoint of the flag. Subsequently, Boston has changed the rules, making it clear that it's no longer going to be treated as a public forum, that only flags that are connected to official events or otherwise sending the city's message can be flown. And so If a Jewish group wants to gather to celebrate Israeli Independence Day, they're not going to be able to fly their flag, but neither will the Christians, and so I hope that makes everybody happy. Another relatively small case, but with a definite religious angle, was called Ramirez against Caviar. Ramirez was sentenced to death in Texas for a murder he had committed years ago, and he wanted his chaplain to be able to come into the execution with him and not only be there, which Texas was prepared to allow, but to touch him while he was being put to death and to pray audibly. And Texas said, that's too much interference. We have to run these things silently and with no one touching the person about to be executed. And the Supreme Court said, we don't believe that you really need to be so restrictive. What are you worried about if the pastor touches the guy on the shoulder and prays audibly? That was 8-1 with a dissent from Justice Thomas, who didn't necessarily disagree with what I just said, but who basically said all these people on death row filling up the courts with frivolous litigation, mostly intended to delay their executions. I just don't want to encourage that, and so I dissent. Coming to the more high-profile cases, Carson against Macon, or Macon, I'm not sure how it's pronounced, was a case from Maine. Maine, in many parts of Maine, there are not enough families in a county or in a school district to be worth building and operating a high school. And so in those districts, the government provides funds for parents to send their kids to a high school that's not in the district. They could be a private school that is actually in the district. It could be a private school anywhere else, or a public school in some other nearby county. And parents basically have free choice to send their kids to an accredited high school, public or private, religious or secular, and the school district pays a set amount of money for their tuition. But, says Maine, you can't go to a school that, this is not their phrase, but it's an old phrase from the case law, that's pervasively religious, that has religion as a major part of what it does. Two students whose parents wanted to send them to such schools sued, lost in the lower courts, and won in the Supreme Court 6-3, saying that, following on a line of cases in recent years that have chipped away at the idea that that religious schools should have to be treated unequally from secular schools because of the Establishment Clause, because government money shouldn't go to be supporting religious education. The Supreme Court says no, and this was a big step forward or backward, a big step one way or the other from previous cases, that you can't discriminate in providing funding to high school kids to go to a private school based on the religious content of its activities. Follow up on that case, Maine has now amended its laws to say that any recipients of state funds may not discriminate in admission or employment based on sexual orientation or gender identity. And to the extent, quoting, to the extent that an educational institution permits religious expression, it cannot discriminate between religions, it means among religions, in so doing. And so they are trying again to make it impossible for these religious schools to get state funding. The schools would have to give up their practice of not only not necessarily admitting students who are gay or trans, I'm not sure the schools care about that, but not having teachers and other employees who are gay and trans, which the schools do care about. and I suppose even more centrally a problem for these schools. If you're going to have prayers, they can't be prayers of your denomination. They have to be non-denominational, and maybe that means they have to be so non-denominational that they would not offend Jews or Muslims. Not clear exactly what that means, but the Associated Press reports that only one religious school has applied for funding for this coming academic year, and neither of the schools that was actually involved in the case has applied because they are not willing to comply with these new requirements. I assume that there'll be further litigation about those requirements, and it's not clear. I think that Maine will win, but we'll see. And what's the next step? These were high schools. The next step may well be elementary schools, where the issues are slightly different, mainly because of the ages of the kids, I guess. But I'm guessing that the court would come out the same way, and that's going to mean that there's really going to be a push for cities around the country to be subsidizing parochial schools, for example, in the same way that they pay for public charter schools. Next case you all know about is called Kennedy against Bremerton School District from Washington State, where the football coach initially had been praying with his players in the locker room, following a custom that had started before the coach's time, and that he didn't understand there was anything wrong with it, but the school found out about it, told him he couldn't do it, and he stopped doing it. But what he then began doing was to kneel and pray on the 50-yard line after the game was over. His team would gather around him, and players from the other team would gather around him. It became a much more public event than it had been when it was just in the locker room. And the school told him he had to stop it. And he said, the game is over. I would be free to pull out my cell phone and check my email, make a personal phone call, chat with friends. The game is over. I'm not on duty. This is my personal expression, and I'm not making anybody or coercing anybody to participate with me. And in fact, I'm even willing to wait until the team has gone off to the locker room so they can't participate with me. The school said that's not enough. You're still doing it in a very visible way. You're still wearing your coach's uniform, if there is one. And in fact, it was still quite a spectacle, because even if his team was no longer there, lots of other people came out from the stands and gathered around him. And it got to the point where there were TV cameras there. It became a very public issue. Meanwhile, he got fired because he refused to stop doing these prayers. And he, meanwhile, moved out of town and got a job somewhere else. And there was an argument that the case was moot, but the Supreme Court wanted to get to the merits and did, and found that his activity was of quote personal prayer was constitutionally protected. And the court finally, after many years of not overruling the Lemon case from the 1970s, which had provided the structure for deciding these Establishment Clause cases, finally said the Lemon test is no longer controlling, and the test is whether, quote, historical practices and understandings show that the activity at issue either would or would not have been considered barred by the Constitution. A test that is likely to lead to lots of other results that most of us will not like, because historical practices and understandings back in the 18th and early 19th centuries did very little to limit government involvement with religious activity. I suppose the next question in this line of cases is going to be, does prayer come back into the school itself, not on the football field, but in the auditorium, in the classroom, as many of us experienced growing up 60 years ago. Historical practices and understandings prior to the 1960s were that school prayer was quite common and widespread, and indeed it has remained common and widespread in some parts of the country, despite the Supreme Court's rulings over the years. And so I don't think it will be terribly long before that issue gets back to the courts. A little known, much less well-known case, and a case that was not actually decided by the court, but they denied certiorari, was called Dr. A against Kathy Hochul, the New York governor. It was one of the very many COVID cases that the court has decided in the last 2.5 years. In this case, New York State required all healthcare workers to be vaccinated. People who had a medical contraindication from vaccination, for example, they're allergic to something in the vaccine, or for some other medical reason shouldn't take the vaccine, were not fired. They could continue to work using standard protective measures, wearing a mask, maybe wearing a shield, maintaining distance if they could, but no religious exemption was allowed. Even if people who had a religious objection to vaccination would use the same protective measures. And the court rejected a challenge to that. In other words, allowed New York State to continue to allow people with medical exemptions to work using protective measures, but they could fire people with religious exemptions, even if those people were willing to use the same protective measures. 3 dissents, Thomas, Alito, and Gorsuch, who made the interesting point of saying, I mean, my reaction, and most people I know have the reaction of saying a medical exemption is something you can't help. I mean, the whole idea here is to protect the health of people, and if it would hurt your health to take a vaccination, then of course you should be exempt. Whereas religious exemptions are more a matter of choice. But of course, many religious people, and some people in this audience, I'm sure, fall in that category, or at least would understand it well. To someone who really believes religious practices are not matters of choice and not optional, and are just as important as for example, a medical decision. And the court has often recognized that principle, but didn't in this case, and it's a curiosity. And the dissents pointed out that allowing people with medical exemptions to use protective measures but not be vaccinated undermines the public health goals of the state equally as allowing religious people to go unvaccinated and use the same protective measures. The sort of obvious difference in my mind is the numbers. Very few people have real medical reasons for not being vaccinated. People who just don't want to be vaccinated because they believe President Trump, or because they believe that vaccines will make them autistic, or who knows what they believe, will claim a religious exemption. They just don't want a vaccination, and it's easy to say, yes, that's my religion. And I think we've seen that in the real world. And so in the real world, it makes sense, I think, to say we're not going to allow religious exemptions, because then we would have a very significant part of the workforce, and in this case, the healthcare workforce, walking around unvaccinated, getting sick and spreading disease. Whereas if we allow only medical exemptions, it will be a minimal number. And I think the court, exercising its discretion to decline a case without having to explain why, probably understood that and ruled in that direction. Not to forget the big case of the term, Dobbs against Jackson Women's Health Organization, the abortion case. As you all know, 5-4 upholding the Mississippi law, but going further than they had to uphold the Mississippi law, and basically saying the federal Constitution doesn't say anything about abortion, including whether it has to be allowed to protect the life or health of the mother. It's up to the states. And the case has come in for an enormous amount of criticism, as you all know, but maybe it's worth spending a few minutes just to be sure that you understand the reasoning of the majority, even if you don't sympathize with them. So the legal issue in the case and the legal doctrine underlying Roe v. Wade and all the subsequent abortion cases is something called substantive due process. The due process clause of the Fifth Amendment says the government may not deprive a person of life, liberty, or property without due process of law. The core meaning of that obviously has to do with procedure. You have to get a fair trial. You have a right to a lawyer. You have a right to confront the witnesses against you, blah, blah, blah. I mean, I shouldn't say blah, blah, blah. These are all very important things, but they all have to do with procedure. But the Supreme Court decades ago came up with the idea that due process also includes some non-procedural protections. There are some things the government just can't do, and they shoehorned that concept into the due process clause of the Fifth Amendment. And so what are those things? Well, marriage is one of them, right? The marriage cases, Loving against Virginia, marriage between people of different races, the same-sex marriage cases more recently come under the same substantive due process heading. Marriage is something the government just can't interfere with, at least in certain ways. Obviously, government does set minimum ages for marriage. The government does, in some states, require you not to be too closely related to the person you're going to marry. But at some point, substantive due process limits the government's ability to prohibit you from getting married. But how far does that go? So there was a 1997 case called Washington against Glucksberg, where Glucksberg said he had a constitutional right to assisted suicide, that is, to have a physician assist him in terminating his own life, given his medical circumstances and life expectancy. And the Supreme Court said, no, it doesn't go that far. And how do we decide? And Glucksberg is just an example. It's not the only case that's raised these issues. But how do we decide what is protected by substantive due process and what is not? And in that case, the court said it protects those fundamental rights and liberties that are objectively, quote, deeply rooted in the nation's history and tradition, and, quote, implicit in the concept of ordered liberty. I'm not sure what implicit in the concept of ordered liberty means, but at least the other one, deeply rooted in the nation's history and tradition, is something I think I can understand the concept. Deeply rooted obviously will mean different things to different people, and the nation's tradition and history will mean different things to different people, but the basic idea, I think, is understandable. And that's why so much of Justice Alito's majority opinion went into history and tradition. Has abortion been legal, or has abortion in fact been outlawed for most of this nation's history? What tradition is there, and how deeply rooted is it? And the many people who in my world made fun of his opinion and disparaged his opinion on the ground that why do we care what the law was in 1820 or 1850 or 1910, perhaps just didn't understand why he was talking about those things. And the reason is he was answering the question, which the court didn't invent just for this case, of is the right to abortion deeply rooted in the nation's history and tradition? To which his answer, and the majority's answer, was no. And indeed, it's an interesting question for people on the other side from Justice Alito, who think that abortion is protected. How far does this substantive due process right go? Is the next case, assuming that Roe against Wade had been upheld and the court had said, yes, substantive due process protects the right, continues to protect the right to an abortion, is the next case plural marriage, right? We now have same-sex marriage. There are certainly people in the country who believe that marriage shouldn't be limited. It shouldn't only be one man and one woman, or one man and one man, and one woman and one woman, but why not 3 people? Why not 5 people? Is there any inherent reason why that's less worthy of protection? Historically, of course, the Mormon Church believed that plural marriage was something that God desired. There's plenty of plural marriage in the Bible. There is still plural marriage in some parts of the world. And so why not? And indeed, why not a right to assisted suicide, which the court rejected back in 1997, but we didn't have same-sex marriage in 1997 either. And then why not various other constitutional rights that lots of people think should exist? I certainly know people who think the Constitution should protect the right to health care for everyone, should protect the right to affordable housing for everyone, should protect the right to at least a basic adequate education for everyone. And why shouldn't those be parts of substantive due process? And why shouldn't the Supreme Court order all the states to protect those things? I don't know the good answer to that, frankly, and many people I know think there is not a good answer to that, and the Supreme Court should indeed establish those rights. But the point of my little digression here is just to say it's not as if abortion is the only issue that comes under this heading. It's a slippery slope in either direction. And I would think that most people, certainly I think at least there ought to be some comprehensible legal test to help us determine what's protected under this concept and what's not protected under this concept, so that it's not just a matter of people saying, well, I think healthcare is a good idea, therefore it's a constitutional right. In terms of subsequent developments here, I mean, we all know from the newspapers that some states have been rushing to pass new anti-abortion laws with very limited exceptions, or perhaps even no exceptions. On the other hand, there's already been at least one lawsuit filed. I think there have been 2, but one that I recall, a Jewish congregation in Florida, Lador Vador, filed a lawsuit soon after the Dobbs decision came down, claiming that the new Florida law banning abortions after 15 weeks would prohibit some members of its congregation from following the dictates of their religion, under which a later abortion is required if necessary to protect the health or mental or physical well-being of the woman. And so sort of putting the court to its test here, here's a Supreme Court that thinks religious practice gets special protection under the First Amendment. And so why not give that kind of protection to someone who says, my religion requires me to get an abortion at, let's say, 20 weeks, because otherwise my mental health is in danger, or my physical health. I'm not expecting this particular case to go far, because it was filed by the congregation, and I took a glance at the complaint. It's not as if they could point to any woman who was a member of the congregation and who was saying, I need an abortion. I don't think it's a very large congregation, and what are the odds that someone who's a member will need an abortion after 15 weeks to protect her health in the foreseeable future, way on standing sorts of issues. But undoubtedly there will come a case in which a woman who can easily show that she's an observant Jew and needs an abortion for health reasons, and has 12 rabbis telling her that this is her religious obligation to get an abortion, will go to court and say the state law prohibiting me is unconstitutional as applied to me, and I certainly hope that woman would win, and might with the current Supreme Court. The last big case of last term was New York State Rifle and Pistol Association against Bruin, the Second Amendment case. So New York law required that someone show, quote, proper cause, whatever that means, to get a license to carry a concealed firearm. And proper cause, part of the problem with it is that it's a pretty vague standard, but that's not the issue on which the court decided the case. But proper cause apparently was interpreted quite differently in New York City from how it was interpreted in rural Western New York. But it was up to the authorities in each county to decide whether someone had proper cause to get a license to carry a concealed firearm. The Supreme Court, as you know, decided the case on much broader grounds, namely that the Second Amendment in general protects people's rights to carry firearms outside the home, because that's something that the Second Amendment, in their view of history, protected back in early years of our republic. I think many people had the reaction to that decision that it was going to create an enormous change on the ground across the country, which I think was not actually true. According to the Supreme Court opinion, only 6 states had the kind of restriction that New York had. Most states allow people to get a license to carry firearms quite easily, with the kinds of exceptions that the Supreme Court says are probably okay. There'll be follow-up litigation on the details, but the court certainly has left the door open for states to say you can't carry a firearm if you've been adjudicated mentally ill and dangerous to yourself or others. You can't carry a firearm if you're a convicted felon. In fact, there's a federal law making it a federal crime to possess a firearm if you're a convicted felon. And the firearms can be prohibited from various special locations, which the court didn't catalog, but many places have gun-free zones around schools, for example, around certain government buildings. New York City, as you may know from the press, has now created a gun-free zone around Times Square, and they have designated Times Square to be quite a large area of Midtown Manhattan, not just what the typical tourist thinks of as Times Square. And signs are beginning to go up around that whole area saying no firearms in this area. And I imagine some places, and perhaps DC will be one of them, will designate large swaths of their territory as gun-free zones, making it more difficult for people to walk around with guns because you'd have to stay out of Times Square. Maybe you'd have to stay out of, the downtown area in Washington, DC. No guns within 10 blocks of the White House or something like that. So we'll see what cities and states come up with and whether they survive legal review. And as Bert Four, who's on the Zoom, pointed out to me when I saw him the other day, nothing prevents private landlords from putting up gun-free zones on their property. So if you're the owner or manager of an office building or a restaurant or a movie theater, you certainly have the right to say no guns in here. And if enough places do that, then people who just like to carry their guns around will find it inconvenient because they have to go home and put their gun away before they can come back and have dinner or see the movie or visit their lawyer in the lawyer's office. So I think I will encourage the ACLU to put up a gun-free zone sign at the front door of the ACLU office. Not that anyone has ever come in with a gun. And in DC, it actually, the Supreme Court decision had no immediate consequences at all because the DC Circuit had already struck down the DC law that had a similar requirement of proper cause as New York's. The DC Circuit found that unconstitutional some years ago. I forget how many, but 5 or 6 years ago, I think. And DC decided not to try to appeal that case to the Supreme Court, thinking we would lose and thereby make things worse for the rest of the country. And so that has been the rule in DC now for a while. The Supreme Court decision made absolutely no difference in DC. What DC did instead was it set up a process which is really pretty onerous for getting your permit. It doesn't say you can't get a permit, but it just says you have to pass a test. You have to show the following, you have to, satisfy the following list of 15 or 18 different things. And so you can't just walk into City Hall and get a gun permit the way you could walk in and get, I'm not sure what kind of permit, a fishing permit. It's actually a much more difficult process. And as one person that I know pointed out, the irony of this decision is that it will, it may actually make things harder for people in rural areas in a state like New York or Pennsylvania, where in the past there's been a sort of a local option. That is, in New York City, it was hard to get a permit, whereas in a rural county in upstate New York, it was probably pretty easy. But now the state may pass new laws like DC did, making the criteria much more definite and making it harder for people to carry guns in rural counties, at the same time that it makes it easier for people to carry guns in urban areas. So again, we'll see. So I've gotten through last term. We still have time left to talk about other things. One thing to mention, of course, that was big news in the Supreme Court last term was the leak when Justice Alito's draft opinion in the abortion case circulated in February. No, the opinion was dated, the draft was dated February and circulated a little bit later in the spring. The investigation has gone on. As far as I know, there have been no leaks about the investigation. But Chief Justice Roberts said something about it when he spoke to the 10th Circuit Judicial Conference recently, and it's, he was not very clear, but it sounded as if there have been some results and we might find out about them before long. So we'll see. Ketanji Brown Jackson was confirmed as the 104th Associate Justice of the Supreme Court, replacing Justice Breyer. Nobody thinks that's going to make any real difference in how the cases come out. But every justice has some idiosyncratic quirks, and so I think there will be at least some cases where she will vote differently from how Justice Breyer would have voted, and we'll see. Most notably so far, she recused herself from the affirmative action case involving Harvard University, which I'll talk about in a moment, because she is on one of Harvard's boards of overseers or trustees or visitors or some name like that. But that even won't make a difference. It's unlikely to make a difference in those decisions because there's a companion case from another school from which she's not recused. And although the court had originally scheduled those cases to be heard together, they've now scheduled them to be argued separately, so she can sit in the North Carolina case and vote in the North Carolina case. And it would be weird if the cases come out differently because of the presence and absence of her vote. But I don't think that's terribly likely. But that brings us to next term. So let's talk about next term. One of the biggest cases, and maybe the biggest, is that affirmative action case. It's called Students for Fair Admission against Harvard, and the other case is Students for Fair Admissions against University of North Carolina at Chapel Hill, both brought by the same advocacy group that doesn't like affirmative action. I think most observers think the court is likely to say, okay, colleges and universities, you've had enough time for this affirmative action business to get the diverse student body that you say you need, and now it's time to stop discriminating against white people and Asian people. The statistics from the Harvard case, I think, are pretty clear that that different standards are applied to different groups of people. And there are certainly several justices, if not a majority, we'll find out, who thinks that that's just flatly unconstitutional, at least for a public university, and that's the case for the University of North Carolina. The Constitution, of course, doesn't constrain private universities like Harvard. That's why private universities, for example, can continue to discriminate based on religion. You can still have a place like Georgetown, where the Jesuit order has a certain amount of control over the university's policies, or Catholic University of America, where the church has even more control. Universities like that are controlled by federal and state law, and so the issues in the cases are somewhat different, and they could conceivably come out differently. But it's likely to be a very enlightening argument when it comes up this fall, and we'll all be watching it closely. Another case that looked like it would be very interesting but may turn out to be less so is called 303 Creative against Elenis. And this is the latest case involving people who, for religious reasons, don't want to get involved in same-sex weddings. There's been the cake baker, there's been the photographer, there's been the florist. The only case that got up to the Supreme Court so far was the cake baker from Colorado, Masterpiece Cake Shop, which they decided based on the statements of some members of the Colorado Civil Rights Commission that the Supreme Court found were bigoted against Christians, and sent the case back for a non-bigoted decision to be made. This case involves a website designer. Her name is Lori Smith. She designs websites for customers, and she has not yet gotten into the business of designing wedding websites, but she says she'd like to expand into that business. But she's not willing to make wedding websites for same-sex couples because she thinks they are against God's will. The state, which I believe is again Colorado, I'm not 100% sure of that, but I think so, says no, if you go into the wedding website business, you have to serve anyone who comes in and wants a website, and so if you don't want to make same-sex wedding websites, you better not go into the wedding website business. The Supreme Court granted that was upheld in the lower courts. The Supreme Court granted cert, and Colorado is now running away from that case as fast as it can. Their brief to the Supreme Court says, well, she can't discriminate against same-sex clients, but the contents of she can in the exercise of her First Amendment right to say what she wants to say and not to say what she doesn't want to say. She doesn't have to create websites that have content she doesn't like, just as a Christian bookstore can sell Christian books and doesn't have to sell Jewish books. That's not discrimination against Jews. That's just that you're a Christian bookstore. Now, what that would mean in practice, I think, is not entirely clear. Can she say to a same-sex couple that wants her to design a website, okay, I'll design your website, but every website that I design has to have this line from Leviticus that says, you know, homosexual sex is an abomination before the Lord. So I think this will be an exceptionally interesting oral argument. I assume that Colorado's lawyer will be grilled on these things quite intensively, and I wonder if he or she will have any good answers. But certainly the question should come as no surprise. I keep waiting for the photographer case to get to the Supreme Court, because that seems, at least to me, to be the hardest one. I mean, putting flowers on tables doesn't require you to really participate in the wedding. And who knows who the florist is anyhow. But if you are the photographer at a wedding, you're going to be right there. Anyone can see who you are. And you really sort of got to get into the spirit of things, at least at the reception, if not at the ceremony itself. And to make someone be a wedding photographer at a wedding that they find disgusting seems to me to raise the issue in a much more pointed way than if you're talking about a florist or the baker of the cake, who doesn't have to be on the site at all, and who knows who the baker is anyway. And somewhat similarly with the website designer, I guess most website designers like to sign their work, so to speak, and show who they are, but you certainly don't have to. You could design a website that no one looking at it would have any idea who created it. But it looks like Colorado is really trying to avoid what it thinks is going to be a decision against it. And indeed, in Colorado's brief, they even suggested to the court that given their current explanation of their position, perhaps the court should just dismiss certiorari as improvidently granted. In other words, reverse its decision to take the case in the first place. A potentially very important case is Moore against Harper, a political redistricting case from North Carolina, in which the so-called independent state legislature theory makes its first real appearance in the Supreme Court. So most of you may know from having read about it in the papers, the Constitution says in two places that certain political powers shall be exercised by the legislature of the states. And it has generally been assumed throughout history that that means by the state government, in whatever way the state government operates. So the legislature can pass a law, the governor can veto it, the state Supreme Court can decide whether it's constitutional under the state constitution. But starting in Bush against Gore, where Justice Scalia first floated this idea, he said, well, when the Constitution says by the legislature thereof, it means by the legislature thereof. It doesn't mean by the state government. It doesn't mean that there's a role for the governor or for the state Supreme Court. I mean, he didn't say all this, but this is how the argument has developed. Legislature means legislature. And so the argument is, so in Moore against Harper, the legislature passed a redistricting law which discriminated against Black people. The state Supreme Court said, no, that violates the state constitution. And the legislature says, well, what business do you have getting involved here? The Constitution gives us this power, period. And at least a couple of justices have expressed some sympathy for that idea. It does run up against a fairly recent decision that went the other way from Arizona. Arizona, a decade or so, the people of Arizona has an initiative and referendum process like most states in the West do and most states in the East don't. So the people can amend their constitution by popular vote. And the people of Arizona amended their constitution to create a nonpartisan redistricting commission so that after the decennial census, the state would be redistricted by this nonpartisan commission instead of being gerrymandered by whoever had the majority in the state government. And that was challenged on the ground that it was only the legislature's job to do that under the US Constitution. And the Supreme Court upheld the nonpartisan commission in Arizona, rejecting the theory that the people couldn't amend their own constitution to take the legislature out of the redistricting process. It seems to me that's a pretty square precedent against the argument that's being made now. But the Supreme Court took this case. There's been much more interest shown in this independent state legislature theory in recent years than there ever had been before. And of course, it could portend very dramatic consequences if it's accepted. You get a state like Pennsylvania, I think, was in the last election, where the legislature is heavily Republican, but the governor is Democratic, and the governor can veto some highly partisan gerrymander. And ultimately, the legislature and the governor have to come to some compromise to get a redistricting plan, or where the state Supreme Court can, as happened recently in, I think, Michigan, but don't hold me to the state, where the state Supreme Court said the legislature's redistricting plan violated the state constitution, which called for a nonpartisan redistricting process. There's a great interest in this theory among Republicans today, because in many states, Republicans have control of the state legislature, even if they can't win statewide votes for things like governors and senators. Of course, the tables could turn at some point in the future, but if the state legislature has unconstrained discretion to do redistricting, aside from any federal statutes like the Voting Rights Act that may constrain it, we could find that gerrymandering gets even worse than it's been in the past. Here's a case you probably haven't heard about, but that could have a real impact on everybody's life. It's called the National Pork Producers Council against Ross. And it has to do with the sale of pork, and how is that going to affect all of you, many of whom don't eat pork? And the answer is, here's how. California has banned the sale of pork in the state of California unless the sow from which the pork derived was housed in a certain kind of a pen, I guess that's what it's called, a pork pen, that almost no pig farms can satisfy. It has to have, so many feet by so many feet and so much air circulation. In other words, it has to be much more humane in the view of the California legislators than most pork farms have. And the National Pork Producers Council has come to court and said, this is an industry-destroying bill. First of all, 15% of all the pork sold in the United States is sold in California. And there is no way to know what pig the pork in your shrink-wrapped package in the supermarket came from. It doesn't work that way. It doesn't have her name on the package. The pigs go to a processing plant. There is no way to tell the bacon that comes out the other end what farm it came from. And so to comply with this California law, basically every pork farmer in America is going to have to comply with the California conditions for how pigs are raised and kept, except if you're, a family farm that slaughters its own pig to eat at the Christmas table. And so this is going to have a devastating effect, and it's going to raise the price of pork for everybody by some enormous amount. And it's unconstitutional under something called the Dormant Commerce Clause, which the Supreme Court has told us in the past. So the Commerce Clause says that only the federal government gets to regulate interstate commerce. States can't regulate interstate commerce. And the Supreme Court has said that that doesn't mean only that when the federal government acts to regulate interstate commerce, it can do so. It also means that the states can't undermine interstate commerce even when Congress has not affirmatively acted to regulate it. And that is somewhat controversial, but has been the law for many, many years. And the Pork Producers Council says this Dormant Commerce Clause means that California can't interfere with interstate commerce in this way. Well, if they are right, I mean, California has exercised that kind of influence around in a nationwide way in other areas too. For example, automobile safety and emission standards, right? California has been ahead of the country on many occasions, requiring emissions controls, requiring other kinds of safety features, requiring certain gas mileage efficiency, for example. Just recently in the news, California has passed a law, and I don't recall the details, but something along the lines of requiring all new cars sold in California to be electric starting in 2030 or something like that. Some of you probably know that better than I do. If the Pork Producers Council wins here, that may mean that California actually can't make those kinds of regulations even to be enforced within its own state, because the economic impact would be nationwide, as it has been. I mean, automakers have complied with California emission standards, for example, because they don't want to make 20% of their cars to suit California standards and 80% that don't. They want to all make the same cars coming out of the assembly line. So it could be a highly important case from an economic point of view. As far as I know, there's no religious angle, except that many Jews could care less about the price of pork. Some other potentially important cases that I'll try to zip through quickly to leave more time for questions. There's an ACLU case I should mention, just because it's an ACLU case, and also a Jewish connected case. It's called Arkansas Times against Waldrip, and this has to do with BDS, the Boycott, Divest, and Sanction movement. The Arkansas Times, a newspaper in Arkansas, refused to comply with a state law that required it to certify that it was not participating in a boycott of Israel in order to get state money, which means state advertising, which had been a significant source of revenue. After the Arkansas Times initially won before a three-judge panel of the Eighth Circuit, finding the Arkansas law to be unconstitutional, the case was reheard en banc, meaning by all the judges of the Eighth Circuit, and they came out the other way, not because they disagreed about what the Constitution meant, but because they disagreed about what the Arkansas law said. And they held that the Arkansas law only regulated the only required the newspaper to certify to what its business practice was, and didn't prohibit it from saying whatever it thought about BDS, which is what Arkansas Times had argued. The Eighth Circuit says you're free to say whatever you want. You just have to certify that you're not discriminating against products made in Israel, the same way you might have to certify that you're not discriminating against products made by Black companies, for example. And so really the case turned not on any large political or First Amendment issue, but just on the meaning of the law. So the ACLU has announced that it plans to seek Supreme Court review. I had no involvement in that case. I was actually a little surprised to see that we are, because I frankly don't think it's a case that the Supreme Court is likely to take. The petition for certiorari is due October 20th, and so I'll read it with interest, and we'll see if the court takes the case. But I will be more surprised if they take it than I will be if they don't. There's an important case under the Indian Child Welfare Act, a civil rights issue called Hayland against Bracken. For many generations, children of Indians, of Native Americans, have been placed for adoption with white families around the country, on the ground, often on the ground that white families could provide them with a better home, more economic resources, more educational background, more stability than a Native American family might be able to provide. Congress passed the Indian Child Welfare Act, I forget when, some years ago, saying that when a Native American child has to be placed in foster care or for adoption, there should be a strong preference to place that child with a Native American family so that they don't lose their cultural heritage. And that's been challenged in this case as basically race discrimination against white people. The Supreme Court took the case, and people who support the Indian Child Welfare Act are very nervous about what the result may be. Another case you may not have heard of called Manu against the United States, and the question in that case is whether people born in American Samoa are United States citizens. As of now, they are considered United States nationals, but not citizens. They can't vote in U.S. elections. They can travel freely to the United States. They have a fairly easy path to citizenship if they want it. But if they are born in Samoa and stay in Samoa and don't seek U.S. citizenship, then they're not U.S. citizens. And Mr. or Ms., I don't remember, Manu says, I'm born in the United States, I'm entitled to be a U.S. citizen. Interestingly, the American Samoan government is totally against this. The legislature unanimously passed a resolution opposing efforts to make Samoans American citizens. The American Samoan government and the American Samoan delegate to Congress, the equivalent of Eleanor Holmes Norton, filed a brief in the Supreme Court saying, don't make us American citizens, we don't want it. And their argument is basically that the American Samoan society is quite different from the U.S. society, and that bringing in the whole baggage of constitutional rights could do irreparable damage to that society. In Samoa, in American Samoa, for example, land is owned in common. There's virtually no private property. It's owned by the tribe, and decisions are made. Many decisions, especially decisions having to do with property, but not limited to property, are made by the tribe. And there are tribal elders who have a lot of influence. It's not, it's not one person, one vote. It's that the tribal elder has a lot of authority, and people defer to the elders. And we may think that that's a old-fashioned way of operating a society, but the people of American Samoa say it's our way and we like it and leave us alone. So interesting case. The Supreme Court has not yet decided whether to take that case or not. It's been scheduled for their conference of October 7th, so we may find out sometime next month. The court did decline to take another case raising the same question not so very many years ago, within the last 15 years, I think. And so they may or may not take this one. They may just decide to leave it alone. I think I'll stop there. Hopefully I have answers to questions. I'll try. Harvey, you're mute if you want to unmute. You're still mute, Harvey. Okay.
I think that now I'm unmuted. Okay. So, Art, I think we will be able to do this. I'm going to use my prerogative as moderator to ask you a couple of opening questions, and then I'll ask people to use there's a reactions button to raise your hand there, and then, you can be unmuted if you want to ask some questions. So I'm going to ask you two questions. One really relates to the stare decisis question in Dobbs. And there was a passage in the opinion talking about the case being egregiously wrong from the start. And I wonder what you think of that as a test. I mean, the case that comes to my mind is the case that held back in 1922 that baseball wasn't in commerce because it wasn't a business, it was a game. And that one, the court itself said was egregiously wrong from the start. I mean, in the 1950s, when they some boxing promoters raised that same antitrust exemption, the court said no, that was only baseball. And then in 1971 or 72, the court basically said, when Curt Flood tried to challenge baseball's reserve clause, that that it was wrong from the start. They were packing in at Yankee Stadium in 1922 to see Babe Ruth. So I'm wondering what you think about that, whether the court has modified its test of what constitutes stare decisis. And then the second question I have relates to the school funding case. And that's, what you think a state with large rural areas where they want to, make sure students get an education, what are the limits after the court's decision on being able to protect students, access to public education or its equivalent?
Yeah, I might have to ask you to enlarge on your second question. I'm not sure I understand it, but let me talk about the first one first. This is not the first time that the court has used that kind of language, and it was a different group of people who liked it the last time they did it. And there was a case called Bowers against Hardwick in 1986 that had to do with whether Texas comes up in so many of these cases, whether Texas's law criminalizing homosexual conduct was constitutional. And the Supreme Court said, sure it is. In fact, the idea that the state couldn't make that kind of conduct criminal is laughable. And it was only 17 years later, not 50, that that case got overruled by Lawrence against Texas. In Lawrence against Texas, I think it was Justice Kennedy who wrote, I'm sure it was Justice Kennedy who wrote the majority opinion. He said Bowers against Hardwick was wrong from the day it was decided. And of course, the Constitution protects people's right to engage in homosexual conduct in the privacy of their bedroom. So stare decisis did not rule the day there, and it made people on the progressive side of the political spectrum very happy to see this 17-year-old Supreme Court case totally overruled on the ground that it had been wrong from the day it was decided. So I don't think there's been any change. It's just a question of who's got 5 votes. Stare decisis counts a lot in cases involving statutory interpretation on the theory that Congress can always fix it if the court interpreted the statute wrongly. It counts a lot in cases where people have financial sorts of reliance interests. They're not going to all of a sudden tell you that the estate plan that you've made in reliance on current law is no longer legal, without any warning. But when we're talking about these big constitutional issues, it's never been an enormous obstacle. And another example is the case involving the Pledge of Allegiance. During World War II, a case involving Jehovah's Witnesses who refused to take the pledge, refused to recite the Pledge of Allegiance in school, went to the Supreme Court, and a majority said, this is a civic exercise that the schools can require, and if you don't like it, too bad. And it was only 2 or 3 years later, after many horrible incidents involving Jehovah's Witnesses being treated very badly for their refusal to take the pledge, that the Supreme Court reversed itself and just said, no, we've changed our mind. We see it differently now, and you have a right not to stand up and salute the flag if you don't want to. And of course, that's one of the big cases in the pantheon of great civil liberties cases. And no one likes to remember that it was, that no one says stare decisis should have prevented the court from reversing itself. So I think that's also not a very valid criticism. And as long as I'm on this rant, all the people who made fun of Justice Alito for citing Matthew Hale's book, Pleas of the Crown, from the 17th century. How can we rely on Hale? He believed in witches and thought witches should be burned. Everybody cites Hale's Pleas of the Crown in any case in which the question is, what was the common law of England before the Revolution, which is a relevant fact in many cases. Hale and Blackstone are like the two major sources, and everybody quotes them. Now, you can argue whether the common law of England about abortion should or shouldn't be relevant in this case, but if you're going to look at history as a relevant consideration, there's nothing wrong with citing Hale. And so people who think, how can we care what someone who believed in witches thought? Well, we do care what someone who believed in witches thought about a whole range of legal issues. And remind me of your second question.
Yeah, so the second question is, I think in Maine, what they were concerned about is making sure that, because they couldn't have, it didn't make sense, there weren't enough people, to attend a public school in some rural areas, so they allowed private schools to fill that gap. What within the confines of that decision do you think a state could do to make sure that students who live in these rural areas can get an education and not be denied admission, for example, on the basis of religion or sexual orientation?
Well, it's possible that students will have to travel a longer distance, right? If the only high schools within 20 miles are religious schools, and if the Supreme Court says that they are entitled to take students only of their own religion, for example, or if their curriculum is full of religious stuff, and a student whose family doesn't believe in that religion doesn't want their kid to be required to go to chapel every Wednesday morning, or recite the Lord's Prayer at the beginning of every school day, and so you don't want to go to that school, then you would just have to travel a further distance. I guess that would be the answer. I don't think it's a practical answer to say that the county has to build a high school for 12 people. I mean, the state could, I suppose, hire people using state funds to set up a small, bring in a trailer and conduct high school in a trailer with teachers paid for by the state. I suppose they could do that if they wanted to.
I guess we'll find out how far they, state can go to still
right.
protect students. If they have to travel 80 or 90 miles, that may not be, much of an option for them. But
right. Well, that's right. And, the option might be you'd have to go to a boarding school, which many people do, although many people wouldn't want to.
Yeah. Let me, I see there's a question that Paul has, so I think I'm able to unmute him. So I think we have time for one or two questions. So
yeah,
Paul,
and I can stay somewhat past 1:30 if there are more questions. Good.
Okay, well, thank you. Two questions. With regard to the state legislatures ultimately getting power over the federal government, can you hear me?
Yes.
Over federal elections, how cataclysmic would that be? It's being described as cataclysmic to our whole democracy. And do you share that view?
I don't. I think there would be some situations where it would result in pretty serious, even more serious gerrymandering than we get now. But it depends on the political alignment of each state, right? If you have a state where the legislature is extremely partisan and no longer has to worry about anything that the governor or the state Supreme Court would say to limit its ability to gerrymander in a radical way, well, then it can do that. How many states will fit that model? I don't know. Some probably will. But in many states, the politics may not be so unbalanced. Some of us are old enough to remember the world, at least as kids, before the one person, one vote decisions of the Supreme Court in the 60s, when states were egregiously gerrymandered, right? The one person, one vote principle didn't apply. And there were lots of states where the rural areas of this, where the districting went by county line, and the large number of rural counties with very few people dominated the state legislature just because every county had a senator, and you'd have one senator from Minneapolis and 28 senators from rural counties. It's not going to get nearly as bad as that because the one person, one vote rule remains in effect. So I'm not saying that we should be complacent about what would happen, but I don't think we really know how terrible it will be. And you had a second question?
Yeah. With regard to guns and the Supreme Court decision impacting New York State's law, they've recalibrated and passed a new law, and now New York City is trying to broaden the definition of Times Square. Yeah. So they declare Times Square a safe zone. I don't know if I came in late for that, but I apologize if I did. But do you think that's going to fly to be able to broaden out? And if you can broaden out Times Square to incorporate many blocks around it that have not already been considered generally Times Square, where does that end?
Yeah, no, I did mention it, but it's still a good question. Yes, I imagine somebody's going to challenge that. And how much will the court defer to the city council's decision about what should be a gun-free zone? I mentioned that some liberal jurisdictions. Here's an example: people who are on the sex offender registry are not allowed to live within 1,000 feet of various places in various states, and in some places, you can't live within 1,000 feet of a school, of a church, of a recreation center, of a liquor store. There are some places where there's basically no place where a person on the sex offender registry is allowed to live. They have to, set up a tent under a bridge someplace, which is really awful. But one can imagine in some liberal jurisdictions that they're going to say, okay, no guns within 1,000 feet of a school, a church, a liquor store, a recreation center, an ACLU office. The last one is a joke. And I'm sure those things will be challenged. And I imagine at some point the Supreme Court is going to say, no, you can't just make up these gun-free zones to the point where you're undercutting the Second Amendment. The same as the ACLU would say, you can't, maybe it's fair to say you can't have noisy demonstrations on the street within 500 feet of a hospital, hospital quiet zones. Okay, but if a city said, well, you can't have a noisy demonstration within 1,000 feet of any hospital, police station, school, recreation center, church or synagogue, that's too much. You can't essentially abolish the First Amendment by zoning. I think the same thing eventually will happen with the Second Amendment.
And quickly, as a subset of that on guns, I do a lot of work on education on the red flag law, also known as an extreme risk protection order. That law is currently considered constitutional. It provides due process by giving people a chance to having a full hearing before a judge after 2 weeks after their gun has been removed. Do you expect, have you seen any indications that the Supreme Court intends to take that law up and review it in a negative way?
No, I doubt it. I think they will insist on a fairly robust kind of due process, as you mentioned. If you didn't get a right to a hearing until 6 months or a year after your gun was taken, that would be a problem. But I don't see that as being a likely problem.
Do you think we could extend that 2 weeks to maybe a month without the court?
Yeah, maybe, yeah.
Paul, I'm going to ask if anybody else has any questions. I think that Bert Ford had asked the question about whether you had discussed the yeshiva use case against LGBTQ on campus. And I know you hadn't, but if you maybe you could just talk for a minute about that, because I think we're going to have to wrap up pretty soon.
Sure. So all I know about it is what I read in the New York Times, probably same as you, Bert. So Yeshiva University claims to be a religious institution and thereby have the ability to say we're not going to give official recognition to an LGBTQ club. The lower court said that it couldn't claim to be a religious institution because when it had revised its charter sometime in the last, 20 years or so, it no longer was incorporated under the religious institutions part of New York state law. It had just reincorporated itself under the educational institutions section and thereby had given up its claim to these kinds of religious discrimination rights. I believe that was the lower court decision. Yeshiva University said, no, we are still a religious, we still have these religious beliefs. I don't know if they cited the Hobby Lobby case, but they should have, right? Even a for-profit business corporation can have religious beliefs. And if Hobby Lobby can, then why can't Yeshiva University? I think there was some news just this morning, and I'm afraid I was at another event, and so I haven't opened my email. So the deadline for recognizing student groups is nigh. It's September or something, and so Yeshiva University ran to the Supreme Court and said, you've got to stay the order of the lower court requiring us to recognize this group. And Justice Sotomayor had entered a short-term stay, but pending further order of the court. And I think the news bulletin this morning, but others have undoubtedly seen it, and I didn't, was that maybe the full court had lifted the stay. I mean, if anyone has seen it, feel free to.
Yeah, I'd heard that too. Actually, one of the other things I've read in the paper, it's kind of interesting because they said that Cardozo, which is part of Yeshiva, and which coincidentally is where my son went to law school, they've had a LGBTQ student group for 10 or 15 years. So it might be hard for them to selectively apply that.
Yeah, So here is SCOTUS blog. In a 5-4 vote, court denies Yeshiva's University request to block state ruling. So yes, so that's this morning's news, that the stay has been lifted and Yeshiva has to go ahead and recognize the group. Now, a distinction the lower court made was very reminiscent of a high-profile local case from the 1980s when the Georgetown Gay Students Club sued Georgetown University seeking official recognition. And eventually the DC Court of Appeals ruled that Georgetown did not have to, quote, recognize the club because that was a matter of its freedom not to say what it didn't want to say, but that it had to give the club equal access with other groups to physical facilities. In other words, equal access to meeting rooms, equal access to the bulletin board, equal access to the Xerox machine, but they didn't have to be a, quote, officially recognized group. And I believe the lower court decision in the Yeshiva University case was along the same lines, that they had to give them equal treatment, but they didn't have to give them the seal of approval, and were free to say, we don't approve of them, but we're required by law to give them equal treatment.
Well, Art, I really appreciate your time. I know everybody here has appreciated it, and you know, we'll revisit the next set of cases next year. And offline, I'm happy to talk with you about the Dormant Commerce Clause. I'm nerdy enough, you know, I covered it in the class I teach, and have written a couple of articles on it. So
yeah, so you should read the briefs in this Port case. You'd find it interesting. Yeah.
Well, thanks again, Art, and thanks everybody for attending.
There's been no official announcement from the court yet, but people think that the courtroom's going to be open to the public again starting in October, and so you can go watch the argument in the Port case.
So it'll be kosher to attend.
That's right.
In person that day. Yeah.
Right, and you can wear a mask with a little pig snout on it.
Well, thanks again, everybody. We'll send out announcements about our next brown bag lunch programs. And again, Art, thanks so much for doing this again.
Sure thing.